Good evening, all. So, people are joining quite fast today. So, I was asking if my sessions and presentations are clear to all the CLAT, UG, PG, and judiciary aspirants who are following me, who are following this channel. RostrumLegal is doing a lot in providing you the best of what it has. Okay, so perhaps uh, sorry, there are technical glitches due to the network issues. So perhaps I was talking like we are expanding our reach. We are doing a lot to reach to the best of the audience and get the best of the contents online. You all are, liberty to ask me the questions. There is a comment from Chitraleka Bhagwati that lectures are better than many paid PG CLAD preparation courses. Uh, Thank you so much. I really that's your appreciation. You should thank Rostrum Legal for providing the best of what it has. Actually, subscribe the channel, follow it. There are various courses also, and I'm going to talk about something today in the middle of my lecture. So please do not leave in the middle. It's an important announcement. So before I begin, let me tell you the topic of today's presentation. Today's presentation is the Government of National Capital Territory of Delhi Amendment Bill, or Act, because it has received the assent of the President. So it now has become an act. So it is the Government of National Capital Territory of Delhi Amendment Act 2021, which has created a great controversy regarding the use the use of power in the it's a game of power in the state of Delhi, that who is going to be the real ruler, in whose hands the real powers would be vested. So let us first understand, because since 2014 at least, that's what we have been seeing. Because ultimately, in 1991, this original act came in 1991. The Government of National Capital Territory of Delhi Act 1991 came, and it was given this kind of special status wherein this became a union territory with a legislative assembly. So elections were conducted, and the chief minister was there. Congress remained in power for a very long period of time in Delhi, and also the Congress remained in power at the center for long 10 years, from 2004 to 2014. And at the same time, the Congress also remained in power in the state of Delhi. So no, conflicts came to sight, and no conflicts arose between the government of Delhi and the central government, because both the governments happen to belong to the same political party. But now the scenarios have changed. Since 2014, there has been a drastic and tremendous change in the political discourses of India. In 2014, we saw a wave of Hindutva ideology that swept across the length and breadth of the country, with BJP coming with a vast majority in 2014 in the Lok Sabha elections. At the same time, Delhi as a state was followed by the landslide victory of the Aam Aadmi Party, because which was this elections, this coming of the Aam Aadmi Party was preceded by a very long and a very successful protest against the Indian National Congress government because of certain corruption charges, and that protest was led by Anna Hazare, and it was who stood by Anna Hazare was Arvind Kejriwal. So Arvind Kejriwal became the face of an anti-corruption protest, and so he became the like light of the day for the people of Delhi, at least, because when he came to power as a party, bringing his political party to the fore, then Aam Aadmi Party became one of the hopes for the, at least for the people of Delhi. Even many people in India looked up to him as a new hope who would work at least for the people. Finally, there's someone who is going to work for the common man. There's someone who's going to work finally for the Aam Aadmi. So this came to power. So then started a different scenario of conflict, a scenario of conflict between the Delhi government and the central government, because there is a very complicated, very delicate distribution of certain issues and powers and subjects between the central government and the state governments. The Delhi government as a state government is deprived of many things that it should not have been. Central government has kept many things in its own hands in for the state of Delhi, particularly because it is also a union territory. Union territories were made especially because these were the territories which was supposed to remain under the direct control of the central government owing to various political and geographical reasons. So it was thought necessary that certain issues relating to the territory of Delhi must be kept directly in the hands of the central government, and the a very limited number of issues must be given to the Delhi government because it's going to have a legislative assembly. So many limited issues, like the issues of a very local nature, like for example, I'm just giving you an example, like the issue of drainage system, like the issue of electricity. These are the issues of a very local nature. So these things came to the fore. So now let us understand this conflict between the Aam Aadmi Party and the BJP government has created so much tension with regard to the distribution of powers and the exercise of powers in the state of Delhi, because the lieutenant governor happens to be the nominee of the central government, who happens to sit in almost every union territory. Even Puducherry has this problem. Delhi government was belonged to the different political party with a different ideology, which wanted to work for the Aam Aadmi, and which was poles apart. Like these ideologies of the Aam Aadmi Party and the BJP, they are poles apart. Aam Aadmi Party never practiced, since in the initial years, never practiced this ideology of this Hindutva, soft Hindutva. But BJP came with this ideology of practicing Hindutva and sweeping away the vast swathes of the country, like in the very initial years in 2014. So this became a very great conflict. Now let us first understand. I'm starting to share the screen now, what this amendment act is all about. Because see, amendment is like LG and Chief Minister of Delhi. These are the two people who who seem to lock their horns on almost every issue, who seem to, like, they're very belligerent for each other, very belligerent people, the Chief Minister of Delhi and the Lieutenant Governor. Because I told you, the LG happens to be the nominee of the central government. He wants to do what the central government commands him to do, and central government commands him to do whatever is contrary to the will of the state government. So that has created so much friction inside the state of Delhi that finally prompted the central government to bring this Government of National Capital of Delhi, National Capital Territory of Delhi Amendment Act 2021, which finally gave so many powers and inclined the inclined the complete powers towards the lieutenant governor. Okay, so that the issues of Delhi, the governance of Delhi should come in complete control of the central government. Now I'm starting to share the screen. See, this is a just an overview. Government of NCT of Delhi Amendment Act 2021. Key points. Provision of, is it visible? Yes, it is. Is it visible? I hope this window is visible. I'm sharing this in the window. Okay. So provisions of the GNCT of Delhi Amendment Act 2021. Okay. Thank you so much for telling me. Okay. See, provisions of the GNCT of Delhi Amendment Act 2021. It amended the sections 21, 24, 33, and 44 of the 1991 Act first. Second, states that the government in the National Capital Territory of Delhi means the Lieutenant Governor of Delhi. This is the biggest controversy so far. People have elected a government in the state of Delhi. They want somebody who can look after their local issues. And this act now says that the government, the word government, does not mean the elected government of the state of Delhi. It means the Lieutenant Governor of Delhi, who is a nominee of the central government. So one of the biggest changes so far in the definition of government in the GNCT Act 1991. They mean to say there is a shift in power. There's a shift in power by the change in definition. Because the definition says that the government does not mean the elected government of the state of Delhi. It means the lieutenant governor of Delhi. Then it gives discretionary powers to the LG even in matters where the legislative assembly of Delhi is empowered to take decisions. So this is the biggest change so far in the definition of government in the GNCT Act 2021. I'm sorry, something went wrong in between because there's a network issue these days, and the weather is also, you know, out of control since last 2 days. It's continuously raining. Please stay online. You all are requested in such cases whenever this happens because this is out of everybody's control. Network is something which is out of everybody's control. So I request all of you to. Am I audible? Am I visible to all of you now? Am I audible? I'm refreshing my page. See, okay, thank you. So, all of you have told me that I am visible and audible now. So, I request all of you, please listen to me carefully. Network issue is something which is out of everybody's control. So, I request all of you that in such cases, you please stay online, at least wait as much as you can, because I try to fix it every time this happens. Okay, and this is happening because of the extreme weather conditions today which are prevalent in the last 2 days, because it's continuously raining. There are heavy thunderstorms and winds going coming and going since last 2 days. So there is a little bit of glitch. There are some technical glitches in the network today. So please bear with this. I'm trying to fix it. Okay. So I request all of you, do not leave if this happens. Do not leave. Just stay online. Okay. Have some patience. So where was I? Okay. So it amended sections 21, 24, 33, and 44 of the 1991 Act. Uh, 1991 Act states that the government in the National Capital Territory of Delhi means the Lieutenant Governor of Delhi. It gives discretionary powers to the LG even in matters where the Legislative Assembly of Delhi is empowered to make laws. Okay, it has given discretionary powers to uh, almost all the powers to the LG. Discretionary powers, discretion, like once you accord a discretion to some position, to some post holder, or to some post, it is like that everybody, he has the liberty, he or she has the liberty to exercise that discretion. And that's what's going to happen in this case also, that once the discretionary powers are given to the LG, almost in every issue, almost in every work the Delhi government that the Delhi government attempts to do, the central government is going to command this lieutenant governor to exercise his discretionary powers and create a hassle in the working of the Delhi government, because the Legislative Assembly was given certain powers in Delhi, and it was empowered to make laws on certain issues, certain local laws on certain issues. But these discretionary powers of the LG are going to act as a rider over the powers of the Legislative Assembly. So this is going to create a biggest hassle in the exercise of powers by the Legislative Assembly of Delhi. So almost it is going to work under the subjugation of the LG, and perhaps it is almost deprived of its own powers. So it seeks to ensure that the LG is necessarily granted an opportunity to give her or his opinion before any decision taken by the Council of Ministers or the Delhi cabinet is implemented. So it is almost like there was an issue. I do not remember. I'm going to take that topic one day. If you remember, and you might have read about, and you might have learned about the appointment processes of the judges of the higher judiciary. And there was a tussle regarding, in the first judge's case in SP Gupta versus Union of India, there was an interpretation that the word consultation is a mere formality, and it does not have the judiciary does not have primacy over the political executive. So that was the issue, that how the consultation process has to take place. Now here also, the LG is necessarily granted an opportunity to give her or his opinion before any decision taken by the Council of Ministers. This Amendment Act has not left any ambiguity. This is very clear, and this is expressly says that every decision that is taken by the Council of Ministers has to be colored by the opinion of the Lieutenant Governor, and which is a necessary ingredient. So LG, being the nominee of the central government, would always do what the central government commands him to do. Okay. Then it bars the assembly or its committees from making rules to take up matters concerning day-to-day administration or to conduct inquiries in relation to administrative decisions. Now, my question is to you, all of you who are listening to me right now. Do you think after the coming of this Amendment Act of 2010-21, Delhi government is potent enough to do anything? Just a very simple and straightforward question. Do you think after the coming up of this Amendment Act of 2021, do you think the Delhi government is continues to remain potent enough to do anything for the people of Delhi? Because whatever is, first of all, nothing is left with the Delhi government. And secondly, that whatever is left, that is also subject to seeking the opinion of the Lieutenant Governor. So this has become like a very big challenge for the any government that comes to power in Delhi to run the administration, to even run its basic administration, day-to-day administration. Okay, see, what is the last point? It bars the assembly or its committees from making rules to take up matters concerning day to day administration or to conduct inquiries in relation to administrative decisions. See, you know, it bars the assembly or its committees from making rules to take up matters from concerning day to day administration or to conduct inquiries in relation to administrative decision. So, can you please tell me that what do you think after the coming of this government of national capital of territory of Delhi Amendment Act 2021, the Delhi government continues to remain potent enough to do anything for the people of Delhi or even run its basic day to day administration? Perhaps not, because the legislative assembly first of all has been barred in its very initial stage to discuss any matter regarding the day-to-day administration, and whatever power is left with the Delhi government, that is also subject to the approval of the lieutenant governor. That has to be, that approval, that opinion of the lieutenant governor has to be necessarily taken. So it's an important issue, it's a debatable issue whether this amendment act was actually needed or not. So my question is to you people, please tell me that if it was required, then why, and if it was not required, then also why? Tell me. Okay, so I'll be dealing with the answers. Then let us understand the criticism. The criticism. The latest amendment bill will greatly reduce the efficiency and timeliness of the Delhi government by making it imperative for it to hold consultations with the LG even when a situation demands urgent action. Exactly. This is the biggest criticism, because the Delhi government's efficiency and timeliness has been greatly reduced. Actually, it is a calibrated attack on the efficiency and timeliness of the Delhi government to stop it from working. These are all political stunts. Do not think they have been brought with some good intentions. These things, whatever any government does, it does it with the intention of, defeating the rival political party. If the political party seems to work for the benefit of the people, and there is a reasonable apprehension for the people, for the other political party, that this party might come in power again with a great majority, because of being liked by majority of people in Delhi. So this apprehension prompts these political parties to bring these kinds of laws. So I was asking you, see, what do you think it is? So there is a there's a comment by Mr. Deepak Kumar. He says that basically this law will not stand in the court. Perhaps this is not going to stay in the court. Let us see, because unless the Supreme Court gives its own comments and judgments, we can only predict like the way you have predicted. This cannot stand in the court. Like being a law student, being a lawyer, I can tell you this suffers from many flaws, and it suffers from the vices of unconstitutionality, and it suffers from the vices of going against the spirit of federalism. That's also written in one of the bullet points. Okay, so the latest amendment will greatly reduce the efficiency and timeliness of the Delhi government by making it imperative for it to hold consultations with the LG even when a situation demands urgent action. Second, significantly, the lieutenant governor is not obliged to give his opinion to the state government within a time frame. Critics argue that the lieutenant governor could politically exploit these unbridled powers to hamper the government's administrative work and thus turn the political tides against the incumbent if he so desires. See, these kinds of political artifices are going to be played at the cost of the benefit and interest of the Aam Aadmi. I'm not talking about the Aam Aadmi party. I'm actually talking about the common man. I'm saying it Aam Aadmi, because who at the end is going to suffer? matlab, out of this political artifice, are we going to attain any productive thing? Obviously not. We are going to attain only one thing: the suffering of the Aam Aadmi, not the party, but the Aam Aadmi. See, this has reduced the efficiency and timeliness of the Delhi government, because the Delhi government has become imperative, it has become mandatory and obligatory for the Delhi government to consult everything with the lieutenant governor. Even if the situation demands an urgent action, the Delhi government cannot do anything. Secondly, the lieutenant governor is also not obliged to give his opinion within a time frame. Now, even the lieutenant governor, if he is being given discretionary powers in certain matters, and also when his opinion is sought on certain issues by the Delhi government, he has not been stipulated. He is not been, he is not. There's no stipulated time. There's no stipulated time frame in which he has to answer. He may take his own time, and when this happens, this is like, once it is gone forever. So critics argue that the LG could politically exploit these unbridled powers to hamper the government's administrative work, and thus turn the political tides against the incumbent if he so desires. This is going to be disaster, because, like, for example, if something comes to the lieutenant governor, he's going to say, okay, I'm keeping it with me, let me think over it, let me take my own time. Now the Delhi government must be like sitting and waiting for the lieutenant governor to reply, and he's not replying. And by the time he could reply, much of the water flew down. Much of the water came down the Ganges, and everything was lost. The time flew away, and the Delhi government could not do anything. So basically, how it's going to turn the political sides against the incumbent if he so desires, because at the end of the day, the people who is going to be blamed? The people. The Aam Aadmi, the majority of the population, does not understand these kinds of complications, that who is actually playing the politics. The majority government, who are the voters. The voters do not understand these kinds of complications. They are not going to say, okay, if the lieutenant governor never let Kejriwal did this, so Kejriwal is not at fault, LG is at fault. That's not going to happen. That's not going to happen. Then it is against the spirit of federalism. Federalism, why federalism? See, we are basically quasi-federal country, a quasi-federal nation. We are almost like federal, but we are not purely federal. You all must have read about our quasi-federal nature. That, which is the example of a pure federalism. Pure federalism, the best example of the pure federalism is that of United States, wherein there is a federation. In almost a purely federal country, a pure federal country, there is a federation. The states come and join together to make up one full-fledged country. But these states always have the liberty to leave and cede away from the union. But Article 1 of Constitution of India says that India, that is Bharat, shall be a union of states. It is not a federation of states. It is a union of states. Okay. Then we have a concept of single citizenship, which is contrary to the spirit of federalism, like that of in the United States, which has a concept of double citizenship. The state gives its own citizenship, while the United States has its own citizenship. Okay. Then the legislative subjects are clearly divided between the center and the states in the United States. We have also divided our subjects very clearly. We have demarcated these subjects into union subjects, state subjects, and concurrent subjects, and the residue subjects. The demarcation is very clear. But we have 4 or 5 circumstances under which the central government gets the power to legislate over these state subjects also. Okay, like emergency, like when the Rajya Sabha passes a resolution by majority that one particular state subjects needs a treatment of a national law, and hence the parliament should make up a law. So there are certain other circumstances also that I don't need to discuss, but this is against the spirit of federalism. Whatever federalism that we practice, we are not a unitary government. almost Professor Upendra Bakshi, I remember his words, he says that we are a, you can call this kind of government, the quasi-federal government that we have, you can call this government a unitary government with some federal features or a federal government with some unitary bias. I'm repeating it. Professor Upendra Bakshi, one of the constitutional experts, a jurist, great jurist, he says you can call it a unitary government with some federal features, a unitary government with some federal features, or a federal government with some unitary bias. So we have like a unitary setup, but that is peppered over with some federal features. Okay, so it is against the spirit of federalism. Why this is against the spirit of federalism? Because if we have an elected Delhi government, and the people want the a particular government and a particular person to become the chief minister of Delhi and come to power, then he's not being allowed to work because of these technical glitches. There is a lieutenant governor sitting over his head who is constantly creating hassles in his working. So basically, this is against the spirit of federalism. And if you study the voting behavior and behavioral patterns of the voters, you are going to be actually surprised by the behavioral patterns. Because perhaps one person, if you study it at a micro level, just one person might be wanting Narendra Modi and the BJP at the central, in the Lok Sabha and the central government. The same person might not be wanting the BJP to come to power in the state. The same person might be wanting the Arvind Kejriwal or the Aam Aadmi Party or any other Congress party or the Samajwadi Party to come to power in the state. There is a difference because people in the Lok Sabha elections are mostly driven by national issues, and people in the state elections, they are mostly driven by their local requirements, local needs. In the state government, they mostly tend to see that, okay, who's going to provide us the cheap electricity, who is going to provide us continuous 24/7 water supply, who's going to treat our roads, who is going to create, who is going to construct the hospitals, who is going to make our roads better, who is going to make our drainage systems better. So these are some very basic local needs which play a very important factor in the elections of the state government, in the state elections. But when it comes to the Lok Sabha elections, people are mostly driven by national issues. Okay, national and international issues also. So if you study it even at a micro level, you would find that one particular individual who is wanting one political party to come to power at the center might not be wanting the same party to come to power in the state. Okay, so the spirit of federalism requires that the people of Delhi, especially when it comes to Delhi, the people of Delhi must be given this liberty to, uh, practice, what option they have been given. Like people of Delhi, their requirements, their day-to-day administration, only they can understand who is the best person who can look after the local requirements of Delhi. People chose Arvind Kejriwal twice so far in the state of Delhi. The same people, the majority of people brought Narendra Modi again back to power in 2019. So we can say that the behavioral patterns of the voters, they differ in the Lok Sabha and the state elections. People are wanting Kejriwal to work at the state level, but this law is not going to let him work. That is why it is said to be against the spirit of federalism. Okay, and that is why we have a clear demarcation between the union subjects and the state subjects, because that is the job of the states to look after these state issues, to look after the local issues. Okay, so it is against the spirit of federalism. Then comes union government's stance, what the union governments wants to say. It is in keeping with the Supreme Court's July 2018 ruling On the ambit of powers of the Lieutenant Governor and the Delhi government following several headliner controversies between the two, it is in keeping with the Supreme Court's July 2018 ruling on the ambit of powers of the LG and the Delhi government following several headliner controversies between the two. There was a judgment by the Supreme Court in July 2018 where it was like they were literally reprimanded by the Supreme Court that there should be a clear demarcation of powers between the LG and the Delhi government, and all the ambiguities should be removed. So, taking that as a tool, taking that comment as a tool, the union government brought this government of NCT of Delhi Amendment Act 2021 and said that we are keeping keeping this law, we are bringing this law in order to enhance and in the furtherance and execution of what the Supreme Court said in July 2018. Then the purported fair objectives of the act include enhancing public accountability and easing out technical ambiguities related to everyday administration. Okay, so the purported fair objectives of the act include enhancing public accountability. Public accountability means and easing out technical ambiguities related to every administration. I don't know how this union government is wanting to create public accountability and easing out technical ambiguities, because it's personally, I must tell you, it has become difficult for me to understand how this Amendment Act is going to ensure public accountability. Perhaps by creating hassles, I think no public accountability is created. So they say, but they still say that the purported fair objective of the act is to enhance public accountability and ease out technical ambiguities related to everyday administration. We should not give like complete discretion to the state government of Delhi. There should be a involvement of the lieutenant governor also in almost every issue. This will increase administrative efficiency of Delhi and will ensure better relationship between the executive and the legislature. I think the union government is so optimistic about creating good relationship between the executive and the legislator. I don't know how this is going to create a better relationship between the executive and the legislator, because the legislators and the executive are themselves going to find themselves in hot waters because of all the hassles this law is creating. The same legislators and the same executors are going to knock the doors of the lieutenant governor for one thing or the other every now and then. Sir, please do this. Sir, please tell us if we are allowed to do this and if we are allowed to do that. I don't know how this is going to enhance the administrative efficiency, but that is the stand of the union government. So any questions so far? The parliamentary form, there are two comments by Siddharth. The parliamentary form of government is based on principle of collective responsibility of the cabinet. Yes, there is a collective responsibility, Article 75. Then elected representatives and the Council of Ministers of Delhi, being accountable to the voters of Delhi, must have the appropriate powers so as to perform their functions effectively and efficiently. Exactly. That is what the principle of federalism demands. That if the Council of Ministers of Delhi are the elected representatives of the people of Delhi, so they must be held accountable directly to the people. If they are not working good, if they are not like working fairly, then then definitely they must not come to power again. The people of Delhi are not going to vote for them in the upcoming elections, definitely. So that is how democracy functions, and that is how democracy works. There is a collective responsibility also. Parliamentary form of government hai हमारी, हमारी collective responsibility hai. But do you think, my question was earlier also to all of you, that do you think this is going to be beneficial in any case? And there came a comment by Mr. Deepak Kumar that this law will not stand in the court. Yes, this law will not stand in the court so far as our apprehension goes, and so far as my and your wisdom goes. This law will not stand in the court. But how do you think that this is going to enhance the public accountability? How do you think this law is going to make the elected representatives in the Council of Ministers of Delhi accountable to the voters of Delhi? Is this the way of making accountable? Perhaps, I don't know how. This is not the appropriate power. All the appropriate powers must be given to the Delhi government. What if I ask you to sit on a chair and I say that I'm not going to allow you to do anything, and then when it comes to you know to vote for you, then I would say definitely I would come to rallies, I will attend political rallies and say this person has done nothing, and I was the only person who did not let him do anything, and I am the same person who is now blaming the other person for not doing anything. That's how it goes. Then Siddharth says the Supreme Court in GNCT of Delhi versus Union of India and another commonly known as Delhi versus LG case. Yes, the constitution bench comprising of then had ruled that LG is an administrative head in the limited sense and is not a governor. Exactly, is not a governor. The Supreme Court said that all the ambiguities regarding the distribution of powers in between the Delhi government and the LG must be sorted out. So union government is understanding, okay, then we are going to sort out every sort of ambiguity. We are going to solve and remove every sort of ambiguity from this structure, and we are going to give all the powers to the lieutenant governor. That's what the union government is doing. That is why Mr. Deepak Kumar is saying that this law will not stand in the court. I'm repeating his statement again and again. He is right. This law is not going to stand, because if we analyze and if we peruse the judgment of the Supreme Court from July 2018, this law is not going to stand in the court at all. Then Aslesha says the thing with Arvind Kejriwal government was that they went ahead of their powers and function and in a way felt superior to the lieutenant governor. Delhi is still a union territory. I understand. That's also true. That might be true. That Delhi is still a union territory. There's no problem in it. Delhi is still a union territory. But do you think that the elected government of Delhi must be removed and completely all the discretionary powers and all the consultation powers must be given to the LG, and the Delhi government and even the legislative assembly should be deprived of even discussing the basic matters of day-to-day administration of Delhi inside the legislative assembly or on the floor of the house? Do you think he is like this is an appropriate manner? I'm not giving, I'm just discussing it. I'm just discussing the pros and cons. Then Siddharth says he's bound by the aid and advice of NCT government in areas other than those exempted. He is bound. Like who is bound? Like LG, na? LG is bound by the aid and advice of NCT government. Now this is a reverse mechanism now. The structure has been completely overhauled. It's upside down now. How it is upside down? Now the government of NCT of Delhi is bound by the aid and advice of the lieutenant governor. That's the biggest change. Okay, that is the biggest change. Okay, so a very important announcement. Now I told you that there is a very important announcement in the beginning of the lecture that RostrumLegal is announcing a CLAT PG 2021 revision course. We are going to where you will find recorded video lectures, more than 10 mock tests. There are going to be live doubt sessions also updated with the latest syllabus, all the study materials and sectional mock tests. This is going to be a revision course, CLAT PG 2021 revision course. So you will find some recorded video lectures. So as and when you feel comfortable in the warmth of your blanket or quilt, you can log into the RostrumLegal site and see the video lectures as and when you feel like. And you will be given more than 10 mock tests. There will be doubt sessions, live doubt sessions. If you come across if you have any ambiguities, then different separately doubt sessions will be conducted. Different latest syllabus will be given to you. It will be updated with the latest syllabus. You'll be given study materials also, and there will be sectional mock test also. So if you want to enroll, and if you want to, because the CLAT PG, the CLAT exam is about to come in the upcoming months. And yes, one thing more, that if owing to this COVID-19 crisis, if the CLAT 2021 exam happens to get delayed in some cases, then your course will also extend. Okay, but for the first 25 subscribers, you're going to get extra 10% discount. You can use this code MHA10 for 10% discount. If you want for, if you want this CLAT PG preparation, this is the best platform you can sign into. So this is a, you use this code MHA10 for 10% discount. And also let me share with you uh, a link of this course. Let me share with you this link of this course. This is important, and I'm posting it in the comment section. So here's a link. RostrumLegal has already done it. Okay. So this is the link. You can find this link in the chat box. You can see what are the basic features of this CLAT PG 2021 revision course. For getting the 10% extra 10% discount, you can be, you have to be in the first 25 subscribers. Okay. Then let's continue. Background. Enactment of Government of NCT of Delhi Act 1991. The GNCTD Act was enacted in 1991 to supplement provisions of the Constitution relating to the Legislative Assembly and the Council of Ministers for the National Capital Territory of Delhi. Okay. The GNCTD Act was enacted in 1991 to supplement provisions of the Constitution relating to the Legislative Assembly and the Council of Ministers for the National Capital Territory of Delhi. It enabled the process of an elected government in Delhi. The Supreme Court had in the past appreciated the 1991 developments, stating that the real purpose behind the Constitution 69th Amendment Act 1991 is to establish a democratic setup and representative form of government wherein the majority has a right to embody their opinions in laws and policies pertaining to the NCT of Delhi, subject to the limitations imposed by the Constitution. Now, this was even praised by the Supreme Court. Now, let us first understand what was there in the 69th Amendment Act 1992. It added two new articles, 239AA and 239AB, under which the Union Territory of Delhi has been given a special status. All these are very important nuggets of information that you have to remember and in fact learn to the, and save it in the most important corner of your mind, that these are very important nuggets of information. Now, Siddharth has posted that provisions are blatantly in contradiction of the constitutional article 239AA, specifically giving power to the Legislative Assembly of NCT of Delhi to make law upon items mentioned in List 2 and List 3. Provisions of what? Please clear this to me. Provisions of the 1991 Act or provisions of the Amendment Act of 2021, Siddharth? Provisions of this Amendment Act of 2021 or provisions of the 1991 Act, the original Act? The Amendment Act, exactly. The Amendment Act. Siddharth says that the Amendment Act of 2021 is blatantly in contradiction of the constitutional article 239 AAA, because 239 AA is very clear. It added two new articles, and I told you in the background section also, because this 69th Amendment Act 1991 was even praised by the Supreme Court. The Supreme Court said that there's going to be a democratic setup and representative form of government wherein the majority has a right to embody their opinions in laws and policies pertaining to the NCT of Delhi, subject to the limitations imposed by the Constitution. So that's important. Now it added two new articles, 239AA and 239AB, under which the Union Territory of Delhi has been given a special status. Article 239AA provides that the Union Territory of Delhi can be called the National Capital Territory of Delhi, and its administrator shall be known as Lieutenant Governor. Okay. Article 239AA provides that the Union Territory of Delhi can be called the National Capital Territory of Delhi, and its administrator shall be known as Lieutenant Governor. Then it also creates a legislative assembly for Delhi. It also creates a legislative assembly for Delhi which can make laws on subjects under the state list and concurrent list, except on these matters: public order, land, and police. Very important point to understand. It creates a legislative assembly for Delhi which can make laws on subjects under the state list and concurrent list. That means all these state subjects and concurrent subjects, they belong exclusively to the elected government of Delhi. Elected government of Delhi. But there are three things which are out of the purview of the Delhi government. One is public order, second is land, and the third is police. Public order, land, and police. Okay. ये पहले से बाहर तीन चीजें, पुलिस डायरेक्टली कंट्रोल में नहीं है, और ये अरविंद केजरीवाल ने पहले भी कहा था, 2014 के बाद भी ये बात उठाई गई थी दिल्ली में कि ऐसा है कि पुलिस कम से कम और पब्लिक ऑर्डर दिल्ली गवर्नमेंट के अंडर आना चाहिए, और हम कंप्लीट स्टेटहुड डिमांड कर रहे हैं दिल्ली के लिए. ठीक है, पुलिस आनी चाहिए. अब पुलिस ही नहीं होगी स्टेट गवर्नमेंट के पास, तो वो क्या करेगी, कैसे काम करेगी? बहुत सारी चीजें होती हैं, फोर्स चाहिए होती है. फोर्स तो एक इमीडिएट हथियार है, एक रिक्वायरमेंट है, इमीडिएट रिक्वायरमेंट है किसी भी स्टेट गवर्नमेंट की. कुछ भी काम करवाना होगा हमें, वी नीड अ फोर्स, वी नीड अ पुलिस. लेकिन नहीं, उसके आउट ऑफ द परव्यू थी. ये आपको याद रखना है. ठीक है. उसके बाद नेक्स्ट इज, it also provides for a council of ministers for Delhi consisting of not more than 10% of the total number of members in the assembly. Okay, तो ये कैप लगा दी थी कि काउंसिल ऑफ मिनिस्टर्स उतने ही बनेंगे जितने टोटल नंबर ऑफ मेंबर्स इन द असेंबली में उसके 10% ही पोर्टफोलियो होल्ड कर पाएंगे. तो जो पोर्टफोलियो होल्डर्स होंगे, जो मिनिस्टर्स होंगे, वो जो टोटल नंबर ऑफ मेंबर्स हैं असेंबली में उसका सिर्फ 10% होगा. तो ज्यादा पोर्टफोलियोज आपको डेली गवर्नमेंट में क्रिएट करने की जरूरत नहीं है, क्योंकि उसके ऊपर कैप है 10% का. Okay. Article 239AB provides that the president may by order suspend the operation of any provision of Article 239AA or of all or any of the provisions of any law made in pursuance of that article. This provision resembles Article 356 President's Rule. Okay. Article 239AB provides that the president may by order suspend the operation of any provision of Article 239AA or of all or any of the provisions of any law made in pursuance of that article. Okay. तो ये जो 239AB है, इसमें ये दिया हुआ है कि प्रेसिडेंट किसी भी वक्त 239AA को सस्पेंड कर सकता है, उसके ऑपरेशन को सस्पेंड कर सकता है. तो यहां पर ये रिजेंबल कर रहा है, ऑलमोस्ट कॉन्ग्रुएंट नहीं है, बट ये रिजेंबल कर रहा है. दिस इज रिजेंबलिंग, दिस प्रोविजन रिजेंबल्स आर्टिकल 356 प्रेसिडेंट्स रूल, क्योंकि वहां पर भी ऐसा ही होता है कि गवर्नर जो है वो एक इज द नॉमिनी of the central government. Governor sends a report to the central government that the constitutional machinery has completely dismantled in this state and the work is not being carried out in consonance with the Constitution of India, and so you kindly impose your president's rule, and so this is followed. So in this case also 239AB gives this power to the president to suspend the operation of 239AA any time and take all the powers into its own hands, like putting president's rule in Delhi. This is like putting president's rule in Delhi. Okay. Then point of friction. However, over the years there was friction between the chief minister and lieutenant governor over power sharing. ये तो मैंने आपको शुरू में ही बता दिया. The focal point of these conflicts was that in case of a difference between the LG and the Council of Ministers on any matter, the matter was referred to by the president by LG for his decision. And pending such a decision, the LG was empowered to take any action on the matter as he deemed right. Okay. So, and pending such a decision, the LG was empowered to take any action on the matter as he deemed right. Okay. So the judgment of the Supreme Court. Now let us see what is the judgment of the Supreme Court in Government of NCT of Delhi versus Union of India and another in 2018 case. The Supreme Court held that the government was not under obligation to seek the concurrence of the LG on its decisions. See, somebody posted this comment that this is in consonance with the I किसी ने यहाँ पे भी बोला था, सिद्धार्थ बजाज ने कि बे जो जजमेंट आया था 2018 का, ये उसके बिल्कुल खिलाफ जा रहा है। तो यहाँ पे देखिए साफ खिलाफ जाता हुआ दिखाई दे रहा है। द गवर्नमेंट वॉज नॉट अंडर ऑब्लिगेशन, द सुप्रीम कोर्ट सेड इट वेरी क्लियर, the government was not under obligation to seek the concurrence of the LG on its decisions. And second, that any differences between them should be resolved keeping in view the constitutional primacy of representative government and cooperative federalism. So primacy must be given, priority must be given to the uh, to, uh, to the to the advice and the will of the representative government or the elected government. Okay, primacy should not be given to the opinion of the LG, and for everything concurrence of the LG is not required. So the government was not under obligation to seek the concurrence of the LG on its decisions, and that any difference between them should be resolved keeping in view the constitutional primacy of representative government and cooperative federalism. Okay, and last is essentially the Supreme Court judgment made it extremely difficult for the LG to refer such matters to the president. That was the actual problem, that it became very difficult because concurrence was not needed according to the Supreme Court. So the Delhi government stopped asking, and when the matter stopped reaching the desk of the LG, he stopped asking the president. So this there was a huge gap came, and almost the local issues of the Delhi fell out of the hands of the central government, and this became very pestering for the central government, which wanted to bring everything in control in its own hands. So essentially the Supreme Court judgment made it extremely difficult for the LG to refer such matters to the president. So that's all about about questions now. I was waiting for the questions. Perhaps so I think it's clear, And then I'm signing off and ending the broadcast. Good evening. Bye bye. Take care, all of you.